All right, we'll take up the next case of Romano versus School Board.
Almost there. Good morning.
Morning.
May it please the court, I am Kathy McHale, and I have the honor of representing Dr. Lori Romano in this matter. I would like to have 12 minutes and 8 minutes in rebuttal, please.
Okay, you may continue.
Thank you. We are here to ask you to reinstate Dr. Romano as the superintendent of Hernando County and reverse the findings of the school board of Hernando County when it wrongfully and without cause terminated Dr. Romano. The vote to terminate Dr. Romano did not say whether it was for cause or no cause, and that's very crucial to our arguments, because of that, she was not given the notice required.
Well, let me ask you about that. Does the contract provide for pre-notice, that you have to have notice before a motion to terminate, or does it just say that you have to, that if she is terminated, she has a right to a post-termination hearing?
Your Honor, it does say that she is required for notice, and she's required to be told why she was fired. In this particular case, we had the vote for no confidence, which was at the workshop at about 5:40 p.m., and then at that same night, she was terminated by a motion that just said motion to terminate, not motion to terminate for a cause.
Right, but the contract says, let's see.
I think you're referring to Section 3A, and it says notice shall be provided.
Yeah, it says by a majority vote, they have the right to terminate the agreement and to remove her from office. They list the reasons. And then it says notice shall be provided to her in writing setting forth the cause of termination. If she contests a for-cause termination, she may request a post-termination hearing. Where is there anything about a pre-termination hearing in the contract?
Because it says that she has to give the notice to provide to her. And secondly, if you recall, there's also a school board policy, 1040.01, that says she has to be given some type of verbal notice of what she has done wrong,
But that's if they're not going to renew her contract.
the non-reemployment.
So
It has
that's a
nothing to do with
totally
this,
different
does it?
thing.
I'm sorry, that has nothing to do with her termination, right? This wasn't a non-renewal.
Our position is that they're in essence non-renewing her.
Well, I mean, you can see how that would work.
I think it's a
mean, you're in the
work,
middle of a
correct.
contract, and they're kind of saying, well, we're not going to renew it. They got to give her notice, and then she tries to fix the problems. But, I mean, this is a totally different thing, it seems to me. So I don't think that 1,400, is that what it is? Or whatever, the number of it.
1040,
Yeah.
whatever it is, yeah.
Yeah, I don't think it applies.
Okay. With regard to the notice, additionally, with this particular situation, we went from, again, the vote of no confidence, and then the vote to terminate, but it doesn't tell her what reasons. And then we get to the notice provisions, okay?
Well,
So
could
that
they
when they're
terminate
giving
her without cause for any reason, but they just might have to pay money? Would that be a fair statement?
Say that again, I'm sorry?
They could terminate her without cause, but have to pay the remainder of her salary for the period of the contract, right?
Actually, the way that the contract is worded is not for cause, it has to be by mutual agreement. It has to be by her retirement, it has to be by incapacity or death. Those are the reasons for without cause. With regard to the notice part, she is supposed to be told, and now let's get into the letter when she's finally told what these reasons are. That's where the crux of this matter is, whether there was competent substantial evidence that gave rise to those. You can't just give
Doesn't the letter
labels.
satisfy the notice?
Excuse me?
Doesn't the letter satisfy the notice requirement in the contract?
It's our position that she should have been told what those reasons were at the school district meeting.
But
They
the
had the
contract
opportunity.
doesn't say that. That might be your position today, but that's not what the contract says.
The contract says that she is to be terminated for cause. She's supposed to know what those reasons are. At the school district meeting, they terminated her for cause, but didn't tell her why they were terminating her for cause.
But then they sent her the letter with the 7 or 8 reasons or whatever it is, and then they also voted to approve that letter. All of this occurred before the effective date of the termination, and it gave your client the opportunity to request the post-termination hearing, which she did and which they held.
Correct.
Where was due process violated in any of that?
Due process was violated because of our position is that the notice that she was given does not give her those specific reasons why she was terminated. They went out of the sunshine. Here, if you look at the actual transcript itself, they had a couple of choices that day. Mr. Alfonso, who was the school district counsel, said you have choices where you need to decide whether you're going to take an off-agenda item. Again, that's a due process argument because they are taking an item that is not on the regular school district agenda for that particular evening, or they
Isn't
could
your
have...
client the only person that can put items on the agenda?
She is the person that puts the items on the agenda,
Isn't she the
yes.
only one that can
But
add
I don't think
items?
I don't think it would be suggested that she would refuse to put something on the agenda. I mean, even if it affects her.
Okay,
But
but
she could. So if they
I don't
wanted
think
to
that's the
address her
person that she is, that she would do that in
I'm not
light of
saying
it.
that either, but if they wanted to address her termination, they would have to put it on, they could put it on the
And
agenda
they could have put it on the
themselves.
agenda. They could have gone and done exactly what they did when they drafted that letter that took 2 weeks outside of the state of the sunshine, because the whole concern about the process was whether they could operate within the sunshine. So what happened was Mr. Alfonso went and met with probably at least 3 of the school board members and came up with those 8 items that are in that particular letter. Now,
what I'm trying to see, they could have done the contract to say that should there be a motion to terminate, there must first be, before they vote on that, there has to be notice, a hearing, et cetera. They could have said that. But instead, the way that provision's written, it says they have a right to terminate it for cause, and they set forth that. Then the next paragraph says, notice shall be given, and then the next part of that says, and she has the right to contest that by requesting a post-termination hearing. So there's no reference in the contract to pre-termination hearing in this situation, and there's no reference to notice before a vote on a motion to terminate, which could have been done. So that's why I think we're all having trouble understanding or accepting your argument on the...
we are limited by what the terms of the contract are, yes.
Well, how about the evidence? Let's talk about, you did request a post-termination hearing. So the second issue you raised is whether there is substantial competent evidence to support the school board's
Correct.
decision. What were the facts most favorable to the school board? And you'd agree that's what applies here, as far as from our court's review, about the, I think it's Moton Elementary School.
Sure, let's talk about Moton, because that really seems to be what the impetus was to terminate her in actuality. So what one needs to know is that Moton obviously was struggling as a school. It was a D-rated school. Dr. Romano developed what was called basically All In for Moton, and beginning in, I believe, January of that year, everybody basically in the school district came to the aid of Moton to try and make it better so that it would stay within the school district. She had the power, as the superintendent of the schools, to handle the personnel matters at that school. That is undisputed. That's within her right to do that, and that's her job to do that. So that's what she did. Now, they make some notions about issues with regard to the union. However, I think if you read the letter from the school district's labor lawyer, not somebody else, but the school district's labor lawyer, with regard to whether there were any violations, there were not. She also...
Did she make a decision to move every single teacher in the school?
She made a decision to transfer some of those teachers, and
Some
then...
or all?
Some.
Well, initially was the notice for all?
No, it was not. I think where the confusion is there's some misinformation in the news media if you're reading the news media articles. But specifically, I believe it was 18 teachers that were to be transferred, and then the remaining teachers were to be non-renewed, which meant that they could then reapply.
Reapply for a different school.
Reapply for a different school or reapply to Moton if they met the criteria. They could have reapplied to Moton. In actuality...
That means they're removed, but they may be put back in. So was her decision to, at least initially, all 47, I believe it was, would be removed?
All 47 some of them would be reassigned, and some of them would be non-renewed. So not all of them.
Right. And theoretically, under her notice, it may be that none come back to that school.
Could have been, yes.
Okay.
Yes. But again, that's within her right to do as a superintendent of the school. It's in the powers of her to do that.
Well, is it within the right of the school board to determine that would be an incompetent decision, if you would? I mean, you wipe out the whole institutional knowledge of the school with regard to students?
There's no evidence that it was incompetent, though. In actuality...
Well, can they conclude that when a superintendent directs that every single teacher of a school be removed for the school year, that is reflective of incompetence? I mean, I've never heard of a school board superintendent ever suggesting something like that.
It actually has been done in Florida. I don't know the statistics, but it definitely has been done in Florida. And the reason, obviously, was because they were afraid that the district was going to lose that particular school. But there's nothing in the record that suggests that it was incompetent.
Well, could incompetence be found from the timing of the decision? Or wasn't it made on the eve of some testing that would affect the school's certification?
It was on the eve of the testing, but if you look at that, they actually tested well, and they still maintain their C rating. So that doesn't necessarily provide any evidence that it was incompetent.
But how do you know that they wouldn't have tested to a B school but for the
How do we not
timing?
know?
Right. But the fact that she made the decision the Friday, or gave the notice the Friday before Monday testing, can the school board decide that was an exceedingly decision of poor judgment, regardless of how the students did? I mean, wouldn't that be within the school board's prerogative?
I guess anybody can have their opinion the way they wish, but the fact is, in this particular case, there was no evidence that was the issue. The issue, in fact, what's interesting...
What evidence could you have other than the decision was made and the school board, can the school board decide that was poor judgment on timing?
I guess the school board could, but in this particular case, the test results and kind of the meat and the pudding is that they're doing well. And what I'd like to also point out as part of the record...
Like I said, we don't know if they would have gotten an A on test and a B on test and a C on test and a D, but can the school board reasonably conclude that disruption likely made the grades, the testing worse than it otherwise would have been?
We don't know that, so that's not something that is substantial competent evidence, because we don't know that. We know that the one school board member who was the pivotal vote, Alunda Prescott, actually, in the record, there's a Facebook message that said she fully supported what Dr. Romano was doing at that school. and then at some point in time changed her mind, I'm assuming because of the politicalness of the issue. I'm going to reserve my time for.
Let me ask you one more question before you sit down. Can the school board, in determining how a superintendent is doing, consider the views of the parents and teachers?
I think, yes, they can, but according to her contract and according to the policies of the school, there were certain evaluation factors, objective evaluation factors, and specifically the one policy says that they should not take subjective factors into consideration.
All right, thank you.
Good morning, Your Honors. Counsel, Dr. Romano. If it pleases the court, my name is Newton Athey, and together with my co-counsel, Dennis Alfonso, Your Honors, we represent the District School Board of Hernando County. Your Honor, we are here on a judicial review of the school board's final action to affirm the termination of Dr. Romano's employment contract for cause. They terminated her for cause specifically for incompetency, misfeasance, insubordination, violation of state and school board policy, as well as breach of her contract. All of those elements were supported by competent substantial evidence at the post-termination due process hearing, a due process hearing that was specifically contracted for between the parties. She was provided the exact level of due process that she contracted for, and for those reasons, Your Honor, the school board would request that the court affirm the school board's final order finding that her termination was for cause.
What school board policy was violated?
Your Honor, it would be, I believe, starting at 10:01 regarding, specifically in regards to Moten, as was discussed by the appellant, her failure to fully advise and counsel school board members regarding the full extent of her actions. Dr. Romano, as the superintendent, has the obligation to advise and counsel the school board as to her recommendations for the operation of the schools, including personnel matters. Important to this, Your Honor, is that it is the school board's final say as to whether to adopt or accept the superintendent's recommendations. The superintendent recommends, the school board adopts or rejects. In this case, she did not fully counsel and advise the school board regarding her intended action. The school board members almost universally said that they were either blindsided, that they weren't fully advised as to what was going to happen, and rather that their understanding was that low-performing teachers were going to be either non-renewed if they were an annual contract employee, or they were going to be transferred if they were a professional services contract.
Opposing counsel argued that it was undisputed that the superintendent had the authority to make personnel decisions. Do you agree or disagree with that?
Your Honor, she has the authority to make recommendations regarding personnel matters to the school board, and then it is up to the school board to either accept that recommendation or to reject it.
So you disagree with that argument?
Yes, Your Honor, and I think that is consistent with the evidence in this case that Dr. Romano certainly believes that she had the authority as superintendent to unilaterally make these personnel decisions of hiring, firing, or transferring when she did not. She had the authority to make recommendations to the school board, and of course, as the superintendent, since it is her duty to oversee the responsible operation of the schools, her recommendation is of course given weight by the school board, but it is not her sole decision. The school board still has to weigh in on it. Your Honor, as it pertains to Dr. Romano's employment, the two governing instruments in this case would, of course, be first.
So the school board, do they regularly decide or, I guess, authorize who's going to be teaching at all the schools in Hernando County?
Your Honor,
Or does Dr. Romano do that?
Dr. Romano would make the recommendation. She would place the item on the agenda for a school board meeting, and then the school board members would vote as part of the consent agenda. They could either vote to approve it pursuant to the consent agenda. They can pull it, or they can pull it for further discussion and then vote on it individually.
That's for all teachers and all the schools in Hernando County?
Yes, Your Honor.
Every year?
Yes.
Okay. All right.
Regarding Dr. Romano's employment, we obviously look first to the language of her contract and then to the language setting forth the reasons and the causes for her termination. Her contract requires or states that the school board has the authority to terminate her for cause. And in this case, the school board did in fact terminate her. They did not non-renew her. They ended her contract before it had concluded. They can terminate her for misfeasance, malfeasance, corruption, incompetency, insubordination, breach of contract, or a material violation of state law, school board policy, things along those lines.
When the decision was first made to fire her, it followed the workshop, and then there was a meeting that evening, right?
Yes, Your Honor. There was an initial vote of no confidence
At the
the workshop, and then there was a subsequent off-agenda item added to the school board meeting to vote to terminate her effective June 30th.
And when that motion was made to terminate her, were there any of these grounds, misfeasance, malfeasance, incompetence, breach of contract, whatever, was there a reason given for the vote that evening?
Yes, Your Honor. Member Nabarud incorporated her statements from the workshop into the discussion at the board meeting. She said she didn't want to overly prolong the meeting at that point, so she was going to rest on the statements she made at the workshop, and those statements largely track the reasons that were set forth in the letter. Moreover, Your Honors,
So she mentioned the fact she didn't give good notice about medical leave and things like that?
Your Honor, I don't know about that specific point, but I do know that
I have a feeling she probably didn't mention that at all.
Your Honor, my understanding is that there was a separate board
I
member.
would think it was the Moten was the issue, wasn't it?
It was, Your Honor. It was Moten as well
I think
as
these other things came later, did they not?
Your Honor, certainly the lack of notice in the record in the personnel file, which is a separate violation of her contract. The lack of,
Somebody went and nitpicked everything at that point and drafted the letter, would be my guess.
Your Honor, there are certainly the arguments that are least in dignity. However, they are things that did occur, and it is a violation of her contract. But importantly, all of it was stuff that predated. These are violations that predated the school board's vote to terminate Dr. Romano's employment.
Okay.
But yes, Your Honor is correct. The three primary reasons that Member Nabarud gave were her incompetent handling of Moten and her failure to fulfill her obligations as superintendent by fully advising board members of the scope of her action, as well as her insubordination in directing school board staff to not turn over a public record to a USF researcher so that they could conduct.
Seemed like kind of a lame one to me too, really. I mean, she had a reason that she thought was a reason not to do that. I mean, it wasn't a public records request. It was a contractual thing to do the survey, correct?
Your Honor, I'd like to address first
I mean, that's not a big deal, really. I mean,
Your Honor, respectfully, the school board's position is that it is because she defied a directive from her employer, the school district, regarding the distribution of a survey that was going to be used
somebody
to
told her there
evaluate
was
her.
no contract with the college, correct?
That is correct, Your Honor, but the practice between the school district and the superintendent and the USF researchers was to proceed without a contract. And the school
it
board
was a
had,
public record, so there was no legal reason for her not to follow the direction, regardless whether there's a contract or not.
that is correct, Your Honor.
It's a public record.
Yes, Your Honor. And further, Your Honors, if we look at the timeline of events, I think it is, I think it would be overly charitable to presume that the stated reason was in fact the genuine reason for failure to turn over the email list, because the directive from the school board to distribute the survey occurred at a board meeting on April the 24th. Moten blew up on April the 13th, which is when the announcement was made. Now, just to be perfectly clear, the vote to approve the survey was placed on the agenda before the announcement that the entire faculty of Moten was going to be non-renewed or transferred. So we have item placed on the agenda, then we have the superintendent's announcement to non-renew or transfer the entire faculty of Moten, and then we have at the very next board meeting the school board approving the survey, saying we're approving the survey, and the minutes reflect that the school board considered the lack of a contract. So they approve the survey, direct that it be distributed. The next day, a board member goes with a researcher to district headquarters and says, all right, let's get the email distribution list. And they say, no, we've been directed by the superintendent not to do that. So the stated reason
You
being,
think probably she was thinking the survey wouldn't come out too well, or that?
Your Honor, I think that's certainly reasonable to infer under the circumstances.
All right.
So that would be the incompetent handling of Moten, also a violation of her obligation to advise the school board members. We have insubordination and failing to follow a directive from the school board regarding the distribution of the survey. And then we also have her failure to fully communicate issues of school board funding to the Hernando County Board of County Commissioners, where she told the Board of County Commissioners that the amounts, the per pupil amount provided at that meeting was incorrect. And that statement in and of itself was incorrect because it failed to acknowledge the local legislative delegation's accomplishment in procuring additional sparsity funding for the school board. So we have the superintendent who was interfacing with the Board of County Commissioners, misrepresenting, or at the very least inaccurately representing, the amount of money that local legislators had obtained for the
That
school
happens
board.
a lot, evidently, because it happened just now in Brevard County. Same thing. But then the CFO quit. Yeah, evidently was, the CFO had messed it up somehow, and the superintendent did the same thing. And then the CFO quit her job and went somewhere else.
Well, and either way, someone responsible for it, I imagine, was no longer in that position later. And that's essentially what happened here. And while I certainly recognize Your Honor's observation that the lack of sick leave and vacation leave notice is certainly the least indignity of the reasons, they nevertheless constitute a breach of her employment contract. And it was a reason given in the termination letter to Dr. Romano.
Okay.
Regarding the appellant's due process arguments, Your Honor, I don't intend to belabor this point too much, but the contract provided for post-termination due process. If the school board was going to fire her, they can fire her. All they have to do is give written notice of the reasons for terminating her if it is termination for cause. In this particular case, that's exactly what happened. What the appellant is trying to argue, and what I'm sure the appellant would like the panel to do today, is to rewrite the contract to include some sort of pre-termination due process clause similar to what is found for professional service contract employees, which are governed by statute. But the school board policy, I think it's 1040, governing the superintendent and school board's relations. It's one of the four that were provided, 1010, 1020, 1030, or 1040, but that specifically provides that the superintendent is exempt from those statutes. And that is because the superintendent her position is unique in that she is the only person in the entire district that reports directly to the school board. All other employees of the school board have some intermediate supervisor or manager between them and the school board. Dr. Romano is the only person who reported directly to the school board. And because she is an appointed superintendent, the school board is required to enter into individual contracts with each superintendent that it hires. That is exactly what they did with Dr. Romano. They were sophisticated parties negotiating at arm's length, and this is the provision that they came up with. It does not include pre-termination due process. She doesn't get notice of notice. All the school board has to do is provide her written notice for the reasons that they are terminating her for cause, and that is what occurred in this case. If there are no further questions from the panel, Your Honor, that concludes my argument.
Thank you.
Thank you. Let me ask you this question. Let's assume the superintendent has in their office a document that's subject to a public records request. All right. And a citizen wants the document. Now, a citizen can make a public records request, follow the statute, and the superintendent would be obligated to produce it.
Correct.
All right. What if the citizen went to the school board and said, I'd like this record, and the school board said, yeah, we don't want to make you go through, the public records request. We'll just tell the superintendent to produce it. is the superintendent, as part of her job responsibilities, required to follow the school board's directive and produce it?
I believe the way that the practice is at the School Board of Hernando County is very strict with regard to the public records request, to
but
follow
if
the
school
law under
board-
119.
If the school board says, we're not going to make the citizen go through a public records request, just go ahead and produce it, it's a public record, it would be insubordination on the part of your client not to.
There is a,
Produce it.
first of all, the superintendent is the secretary of the records. So she's the one that makes that determination, and there's a chain of command with regard to that.
Right.
And in
But
particular.
my hypothetical, the
Yes.
school board says, superintendent, produce the document. We don't see any reason to make this citizen, in this case, go through the formal public request process.
I don't think that's the way the public records law works here in this particular situation.
But can the school board direct a superintendent to produce documents to a citizen?
I don't think they can in this particular situation because she is the secretary of the record, so she is the one producing the documents, not the school board members themselves.
So who's her boss?
All of the school board.
Right, so that's
Yes.
why I didn't say one school board member, I said the school board, publicly held meeting, and they say, produce these documents to this citizen.
But that's a different hypothetical than what actually occurred here. In that particular situation at a school board meeting, is that what your hypothetical is? Produce this document?
Well, give the emails, which are public records, provide these emails to this citizen.
I think that's a different scenario than the facts that we have here. So it's not a hypothetical that applies
How's
in
it
this
different?
particular situation.
How's it different?
Well, in this particular situation, you have somebody who is a member of the USF team that was going to do the survey. You have the facts that there was no contract in place for that survey. You even have
I'm fine without the contract.
Okay, you even have the record evidence that shows that the man in charge of the survey didn't know whether he was going to be doing it personally or whether he was going to be doing it
Were the
under
emails
USF.
public record, were the email addresses public records?
The email addresses are public records, but you have to go through the process to get them, and it has to be, just can't give everybody's email address out. That's not a proper public records request to say, I want all of the email addresses. You have to have a reason for it, which gets back to the contract, which was the reason.
I'm just trying to figure out, if the school board tells the superintendent, produce these email addresses, and it's a public record, I'm trying to figure out the relevance of I'm not going to produce them because there's no contract between the school board and the person doing the survey.
Well, you have to know whether the person that's asking for the records is the proper person for the proper method for them. And in this particular case, at that time when they were requested, there wasn't a contract. So if your hypothetical is correct, then why did it take a week or 10 days later for Mr. Alfonso to have to get the contract initiated with the USF? If that was the case, then somebody should have, done it the other way.
Could a parent have gone through the formal request and gotten all these email addresses, just out of curiosity?
Can a parent? I don't know whether a parent could. I think there has to be a reason why they're getting those records.
For a public record?
Right.
Okay. All right, go ahead.
And just to follow up on the particular issue with regard to the email situation, they said that there may have been a probable violation of a public records, but that does not give grounds for the termination for Dr. Romano. A probable ground is not the competent substantial evidence. With regard to the alleged misrepresentation to the Hernando County Board of County Commissioners, Dr. Romano was correct, and if you look at the record, specifically R154 to 159, you will see the additional information that was provided by the school district's director of finance, which clarified this issue, that $2.07 was the actual amount when all was said and done, when all of the legislature got completed with what they were giving out to the school systems. So there's no issue with regard to her being inaccurate or incompetent with regard to this particular information.
Well, on the substantial competent evidence to support termination, they gave the letter with 7 reasons, 8 reasons, whatever it was. We don't have to find that there was substantial competent evidence on all 8, right? We could find that there's evidence to
Correct.
support one of them.
That's correct.
And some, as I think the school board acknowledged, some are more significant violations than other. But if there's substantial competent evidence to support, let's say the Moten termination, which is probably the most serious. That's all we're looking for today, right?
That is correct. You don't have to find the.
And the
for
evidence
everything.
that we've talked about or that was presented includes the decision to remove all 40 whatever teachers, 47 teachers, not to do it in any kind of consultation with the school board, the timing of the decision right before the testing, that's evidence. The conclusion is incompetence, but the evidence would be those three things, right? That's evidence in the record that could support a conclusion of incompetence, which is grounds for termination for cause.
And the evidence that I'd like you to look at are the talking points that Dr. Romano utilized when she talked to each particular
But that's
school board
evidence in the
member.
record that the school board could have relied upon in reaching its conclusion of incompetence.
Yes, that is correct. But what I'd like you to look at is what the record actually is to determine what they reasonably relied upon. And if you look at the talking points you looked at, Dr. Romano was very clear on what she specifically said to each one of them. Some of them said they had no idea what she was doing, but if you look clearly at the talking points, she clearly states exactly what she's doing with each of the different classifications of the teachers themselves. So in conclusion, the ramifications of the words in the letter and the resulting media attention has ruined Dr. Romano's stellar educational career. If this was a case simply a case of her not doing her job, or that she somehow was in one of these malfeasance, misfeasance, incompetent, insubordinate, all of those, then why was the district excelling with her as superintendent? Why did the district go from a B- to an almost A under her tenure? Why did they renew her contract and keep her as a superintendent up until this point in time? Thank you for your time.
All right, thank you. All right, court will be in recess.